Let's talk about the enforceability of agreements, not just the agreement to mediate, but the mediated settlement agreements. But the agreement to mediate. Somebody comes to you, it's a post-divorce case. It says in their separation agreement that if a dispute arises out of related to their agreement, they will go to mediation before they go to court. And the client says to you, I don't want to mediate. I just want to go to court. Do I have to? Is that an enforceable duty?
May or shall, depends.
If the agreement says shall. Okay. So the agreement to mediate is an enforceable obligation. What if the client says to you, but I need a restraining order, or I'm fearful for my child? Do I have to go mediate?
That's one of the exceptions.
Okay, right? So the domestic violence is an exception.
Well, would it be that you have the restraining order, which would make the exception, or the client thinking, I need one, because one creates a legal obligation for them not to be in the same room, and the other is just an excuse?
So 209A has an exception. It says that the judge can't make parties mediate, so that's going to vitiate the contractual duty. And I would say that probably a court would find that it was contrary to public policy to say somebody has to go mediate when there's an issue of, say, child safety. So that might be one of those exceptions. But except for those rare cases, these agreements to mediate are enforceable. Now, in the separation agreements that I do, I have, in most of my cases, that kind of tiered negotiation, mediation, then court or arbitration, and a paragraph that says, in exigent circumstances, you can go right to court. So it gives people an out. Now, they've worked with you, they've mediated, they've reached an agreement. Let's say that before reaching a final separation agreement, they reach an interim agreement. It says, you know, we're going to divide the credit card usage this way, and one party's going to have the marital home, the other is going to leave, and they'll divide the checking account 50-50. Enforceable?
No.
And why isn't it enforceable?
The court hasn't approved it yet.
But it's a contract.
And?
Yeah. So are contracts only enforceable if a judge approves them?
No.
In a divorce setting, I believe yes.
Okay. So here's my suggestion. Karen,
So I've seen contracts that say until there's a final resolution of the case, any interim agreement reached by the parties will be considered enforceable by the court, and if you're aggrieved by this, you can go to the court.
you get a temporary order.
Right, exactly.
Right. So here's my suggestion. When you work with parties and they need an interim agreement, and that happens very, very often. In fact, in some cases, we have a series of interim agreements. I would suggest to the parties that they might want to put something in their contract, in their interim agreement, as to whether it's enforceable through a motion for temporary order or not. In other words, they can say this will be enforceable, but it's not final and binding with respect to an equitable distribution of marital assets, or it is final and binding with regard to an equitable distribution of marital assets. It's a pre-divorce distribution that they intend to be bound by.